Kristin Wilkinson, voter number 52540. Mr. Berry, have you received the plea to the jurisdiction and answer?
I got it this morning, yes.
Okay.
I assume, since she sent that late last night, I assume that you've not received any telephone calls or messages from her this morning that she's running late.
Revocation proceeding pursuant to section 2.23 of the Texas Rules of Disciplinary Procedure. We're seeking to revoke, sorry, Ms. Wilkinson.
I don't mean stand up, I mean straight. I mean
Raise my
talk
voice a
louder.
little bit, I can do that. With the microphone, it's hard to judge, so I apologize. We're seeking to revoke the two-year probated portion of her suspension for failure to comply with terms of the judgment. Specifically, she's failed to make any payments towards restitution or towards attorney's fees in this matter. Petition for revocation of probation was filed with the board on June the 25th, 2013, and the respondent was personally served on July the 3rd, 2013, with the petition and notice of the hearing. The records affidavit was filed on July the 9th, 2013, and proof of service was filed with the board on July the 12th, 2013. On January 21, 2011, a judgment of partially probated suspension was entered against Kristin Wilkinson in cause number H00808-27321, style Commission for Lawyer Discipline Petitioner versus Kristin D. Wilkinson, respondent. In that judgment, an evidentiary panel of the State Bar of Texas District 4E Grievance Committee found that Ms. Wilkinson had committed violations of the Texas Disciplinary Rules of Professional Conduct number 1.01B1, 1.04A, 1.14A, 1.15D, and 8.04A3. The panel handed down a sanction of a 48-month partially probated suspension beginning on May 1, 2011 and ending May 1, 2015. That judgment had 24 months of active suspension starting May 1st, 2011 and finishing on April the 30th, 2013, and then a 24-month probated suspension beginning May 1, 2013 and ending May 1, 2015. The respondent was ordered to pay attorney's fees and direct expenses to the State Bar of Texas in the amount of $15,458.59 on or before March the 1st, 2013. Respondent did not pay any attorney's fees or direct expenses to the State Bar on or before that deadline, thus violating the terms of probation number 8. Respondent was ordered to pay restitution on or before December the 31st, 2011 to Adrian U. West in the amount of $25,000. Respondent did not pay any restitution on or before December 31st to Ms. West. Thus, she violated term of probation number 9. These inactions result in a violation of probationary term number 1. At this time, I'd like to introduce the following exhibits. Exhibit number 1 is the business records affidavit filed with BODA on June the 9th, 2013, which includes respondent's disciplinary history. Exhibit number 2 is an email from Nancy Ashcraft to Karen Wilkinson, dated May the 3rd, 2013. Exhibit number 3 is a copy of an email from Karen Wilkinson to Nancy Ashcraft, dated May 3rd, 2013. I think I'll go ahead and read those, but I'll actually ask for them to be admitted later, but I'll go ahead and give them to you now. Exhibit number 4 is a copy of a demand letter from Nancy Ashcraft to Karen Wilkinson dated October the 9th, 2012. And exhibit number 5 is a copy of a demand letter from Nancy Ashcraft to Karen Wilkinson dating May the 15th, 2013. And exhibit number 6 is the original certificate of Blake Hawthorne, Clerk of the Supreme Court, dated July 2013, showing that Ms. Wilkinson is currently licensed and authorized to practice law in the state of Texas. May I approach?
Yes, I take that as an offer of all 6 exhibits, and hearing no objection to that, I'm going to go ahead and admit all 6.
Okay, thank you.
Otherwise, I'll forget to do it.
All right, at this time, I'd call Nancy Ashcraft. Could you please state your name for the record?
Nancy Ashcraft.
And how are you employed, Ms. Ashcraft?
I'm the compliance monitor for the State Bar of Texas, Office of Chief Disciplinary Counsel.
And how long have you been in that position?
7 years.
Okay, and in that position, are you familiar with cause number H00H80827321, Commission for Lawyer Discipline versus Kristin Wilkinson?
Yes.
What are the terms of that judgment?
A judgment of partially probated suspension entered January 21st, 2011. Attorney's fees to the State Bar of Texas in the amount of $15,458.59 due March 1st, 2013. Restitution to Adrian West in the amount of $25,000 due December 31st, 2011. She was actively suspended from May 1st, 2011 through April 30th, 2013. Probated suspension from May 1st, 2013 through May 1st, 2015.
Okay, was she also ordered to notify the State Bar of her current mailing, residence, and business address according to the terms of that judgment?
That's correct.
Thank you. Which of those terms did Ms. Wilkinson fail to comply with?
She has not paid the necessary attorney's fees and expenses to the State Bar of Texas. She has not paid restitution to Ms. Adrian West, and she has not notified us of her address, her mailing addresses and residence addresses. Her
Okay.
residence address, I'm sorry, we do have her mailing address.
Okay. Did we recently receive her residence address?
Not from her.
Not from her. She provided it to membership though recently?
Correct.
Okay. Has she paid any amounts of money at all towards settlements, towards the restitution or towards attorney's fees?
No, she has not.
Okay. What attempts did you make to get her to comply?
In this judgment, I had notified her in May of 2012 regarding the attorney's fees, the restitution that was owed, and in this judgment, and that the restitution was due December 31st, 2011, and I had reminded her of previous attorney's fees that were owed, and at that time told her that the attorney's fees were due in March of 2013. And then October, I sent a letter to her demanding payment for the attorney's fees and restitution owed. I'm sorry, for the restitution owed in this matter and a previous matter, and then in May of 2013, we sent a final demand letter to her.
Okay. Did any of these contacts result in any attempt by Ms. Wilkinson to comply with the judgment?
She has not complied with the judgment.
Has she made any attempt to?
No, she has not.
Okay. Have you spoken to Ms. Wilkinson on the telephone at any time?
No, I have not. I've communicated with her by email.
And can you tell the board why?
Ms. Wilkinson will turn my conversations around and say that I say things that I don't abide by what I have told her to do.
So was that from a previous case?
Correct.
So are you familiar then with cause number H009050200881, Commission for Lawyer Discipline versus Kristin Diane Wilkinson?
Yes, I am.
And that was a judgment from 2009?
Correct. It was entered July 22nd, 2009.
And in that case, Ms. Wilkinson was actively suspended for 6 months?
That's correct, from September 1st, 2009 through February 28th, 2010.
And what were the terms of that judgment?
Under that suspension, she was also ordered to notify clients and courts and submit her license and bar card, and to pay attorney's fees in the amount of $23,153.03 by February 28, 2010.
Did she comply with the terms of that judgment?
She has not fully complied with those terms.
Okay. Did she make an effort, did she pay towards the attorney's fees?
She has paid toward the attorney's fees through a payment agreement that we set up, that we made.
Okay. By what date was she supposed to have paid those fees?
All of the fees by February 28, 2010,
Okay.
according to the judgment.
According to the judgment. Had she
Correct.
paid anything at that time?
No, she had not.
Okay. So after that date, then you had contact with her trying to get compliance on that judgment?
Correct.
And what was the result of?
Of those contacts, we she agreed to a payment plan to make payments of $500 a month beginning June 1st, 2010.
And who made the offer to pay the $500 a month?
She had made the offer to pay that.
Did she do that in writing?
Yes, she did.
And you accepted that offer?
We did not accept that particular offer because she was requesting a rule of 60 days if she defaulted on the payment. And we set up a payment plan for her to pay $500 a month beginning June 1st, 2010.
Okay, so the only part of it you did not accept was she wanted 60 days to cure if she
Correct.
was late. Okay, was she ever late in those payments?
Yes,
And did you try to work with her to allow her to make payments late in that case?
numerous times, yes.
So even though you didn't accept that term, you still worked with her to
I
try to
did.
get that done? So in total, how much did she pay towards that judgment?
She has paid a total of $9,000 toward that judgment.
So how much does she still owe?
She owes a balance of $15,096.57 in that previous judgment.
And what attempts did you make to get compliance after you entered into after she agreed to pay $500 a month towards that judgment?
We had communicated by email and granted extensions to her. It was all by email, basically, that she would say that she could not pay this amount a certain month, and could she make a partial payment, and we agreed to that. I agreed to that up until January of 2012, and then she did not submit any more payments after. She had not paid anything as of December 9th, 2011 was her last payment, and that was for the November 1st, 2011 payment.
So after that, she totally ceased sending any money at all, is that correct? Okay. Those are all the questions I have. Board has any?
Anybody have any questions of Ms. Ashcraft?
When was the last time she made a payment on that prior judgment?
It was in December of 2011, December 9th, 2011, in the amount of $500, which paid her through the November 1st, 2011.
So she hasn't made a payment in almost 2 years.
No,
Is
sir.
that correct?
That's correct.
I have a question. With respect to the judgment that we're here on today,
Yes, sir.
did she request a payment plan for this one?
No, ma'am.
Ms. Ashcraft, do you have the exhibits in front of you that have been offered?
I do. Yes, sir.
Okay. Exhibit 2 is an email from you,
Yes, sir.
and it talks about payments. Is this exhibit 2 and the payments that are discussed in that, is that with regard to the first judgment?
The first paragraph is, yes, sir.
Okay. How about the second paragraph?
The second paragraph is the current judgment, where she owes Ms. West was ordered to pay Ms. West $25,000 in the attorney's fees in the amount of $15,458.59.
What is the amount she owes in total on both judgments?
In total, to date, with interest, is $57,350.65. That is restitution and attorney's fees.
interest on the unpaid amount?
Yes, sir, that includes the interest.
When was the last time you heard from her?
Just one moment.
I mean, just approximately.
Sir?
Just approximately. Is it?
In November of 2012.
Any other questions?
I have one more. Ms. Ashcraft, after you sent the last demand letter,
Yes, ma'am.
did Ms. Wilkinson respond by filing suit in Travis County?
She did.
And she named you as one of the defendants in that, based on that demand letter?
Yes.
I'm sorry, what was the nature of the last communication in November 2012?
She thanked me for my letter in October to her, and told me that she didn't have the money to pay. There were some, she was trying to get settled and trying to get her finances in order, so.
Thanks.
Ms. Wilkinson? Yes. Glad you could make it. We have the first witness is on the stand in your case. If you'd like to, why don't we take a couple minutes and let Ms. Wilkinson get situated at the council table, and then we'll continue.
I have no more questions for this witness, so I'll pass it.
Go ahead and remain seated. Ms. Wilkinson may have some questions for you. Whenever you're ready, just let us know. Take time to get.
Yeah, I'm sorry, but I thought this was supposed to be starting at 9:30, and I'm sorry that I'm late, but I have 9:20. So.
We're good. Just
Okay.
take your time, and we're ready to hear you whenever you're ready.
Can I get the name, your name, please?
I'm Nancy Ashcraft.
Ms. Ashcraft, I don't have the benefit of knowing what you just testified to, so I'm going to ask you if you could just tell me what you've said so far. How long have
Testified.
you been testifying this morning?
But when the proceedings started, about 10 minutes.
Would you please let me know what you said so far?
Well, I testified regarding the judgments that are regarding the judgment.
Well, instead of telling me the subject matter of what you testified about, if you could tell me what you've said.
I have testified to what the judgments state and that you have not complied with the terms of the judgment. Regarding payment to Ms. West, attorney's fees in this matter.
In which matter? In the West case?
Correct.
Okay. And have you testified about any other case?
The case regarding the active suspension, your previous case, and that you had paid attorney's fees through December 2011 for the last payment you made was December of 2011, and it was for the November 1st, 2011 payment. It's due
And how much has been paid on that so far?
$9,000.
And how much is due?
The date on that case, on the previous case, the amount.
On the Calhoun case?
Pardon?
On the Calhoun case?
$15,096.57.
That's how much is due?
Correct.
Okay. I thought you just said that $9,000 has been paid.
That's correct.
Okay. Had you ever had any communication with me about why why only the full amount has not been paid?
We have communicated some with that regarding emails with your financial stresses.
And the death of Miss Calhoun, who happens to be my aunt.
Been
I'm
very,
gonna object, that's not relevant.
It's very.
I overrule the objection.
Well, you've been very upset about the issue with Ms. Calhoun and with the
Pardon
State
me, I
Bar.
object to that as non-responsive.
Sustained objection. If she's communicated with you on it, just,
Correct.
yeah, that's sufficient.
So what, in your understanding, was the explanation that was given to you for the amount of the judgments not being paid in full so far?
Excuse me, Miss, it may help you some, since I don't think you've had an opportunity to look at some of the record, the exhibits, but you might look at Exhibit 3, which is.
Oh, she did enter those. Okay.
Yes, which is an email from you, which has the discussion, probably along many of the ways, and it may already be in evidence. The
Okay.
questions the issues that you want to discuss. And I don't want to stop you from putting on whatever you want, but I didn't know if you were aware.
I appreciate that. I had not had
Okay.
a chance to look at it, but I'm familiar with the email.
Right. I just thought that might assist you in
Thank you.
getting some of your points.
I appreciate that. Do you think that, is it your opinion that the judgments have not been paid because of some intentional refusal on my behalf to pay them?
I'm going to object. That calls for speculation.
No, we've had numerous telephone conversations, email communications, and she's obviously formed an opinion, which is
I'll
brought her
overrule
here
the
today.
objection.
I haven't formed an opinion. You haven't paid what was owed, and you haven't made any payments since December of 2011.
And are you aware of my status at the State Bar in 2011, or since the date that you just gave us?
Been suspended, yes, on a partially probated suspension.
Okay. You know what, I filed my answer, and I need to take up a procedural matter before I continue to go on. And I brought copies of my answer if you haven't seen it.
Why don't we do this, since, and I'm sure you're playing catch up, you might not have looked at the exhibits, and I understand that you want to go ahead and argue, I guess, a plea to the jurisdiction. We have another matter. Why don't we recess this hearing, let you get your notes and stuff kind of organized, kind of figure out where you are. Let us go ahead and do the other matter, and then we can take up this one. That'll give you a little bit of time to kind of look over everything, and rather than starting right out of the box. Is that okay?
That's fine.
Okay. We are going into recess on 52540, Kristin Wilkinson. And we're going to take a couple minutes, let Ms. Are we ready to proceed to resume on the Wilkinson matter? It's 52540. Mr. Berry? Ms. Wilkinson? Okay. Did you want to go ahead and take up the plea to the jurisdiction?
Yes, I would. Also, just as, just to,
You might want to approach do it from the podium. I think we can probably hear you better. Or from the lectern, I guess. It's not really a podium.
I would like just to object. The proceedings were scheduled, and I was given notice that the proceedings were going to start at 9:30. I got here at 9:20, and was told that the proceedings had been going on. Ms. Ashcraft had been testifying for 10 minutes. So I object to not being given proper notice of the hearing And I moved to strike all of the testimony so far. I have no idea what's been said.
When you say that you were told that the hearing was starting at 9:30, who told you that?
I was given a written notice of the hearing,
Who gave you the written notice?
Ms. DeBerry.
Okay, so are you saying that this court, the board, did not give you notice of the hearing?
Well, I'm saying that I object to improper notice.
Okay, but what I'm asking you is, did the board provide notice of this hearing?
I have not received any notice from the board. I received a copy of the pleading, which had a notice of hearing on the last page. That is the only notice.
Do you have
I've
that
received.
with you?
I'm sure I do. Would you like to see it?
Mhm.
Sorry, but I just finished a brief in a court of appeals, so this file is a little messy, so I'm gonna dig. I'm usually immaculate in my organization, but. Never mind, I strike my objection. I'm late and my notice says 9 o'clock in the morning, so I apologize for that.
You withdraw your objection?
I withdraw my objection and I apologize. I haven't had any sleep. I just
Not a problem.
I literally have not slept. And anyway, okay. If I could, I'd like to take up my plea to the jurisdiction. I have, before this proceeding was filed, I filed a bill of review in Travis County, in the district court in Travis County, seeking to vacate both of these suspension judgments against me, based on constitutional violations of substantial and procedural due process. In the West case, I was subpoenaed witnesses that I was not allowed to call and could not put on a defense. In addition, I'm sorry, but I haven't had anything to drink on. I just drove down here and my health is really dry. So, I was also asked during the proceeding to cut short my defense. I've never seen any sort of proceeding in any legal proceeding as I have before the evidentiary panels in both my Aunt Vera's case as well as in the West case. And it is significant because in my Aunt Vera's case, I was taking care of her. I wasn't representing her as an attorney. And she's a member of my family. All of our family was taking care of her. She had severe mental illness.
She's testifying about the underlying case. We're not
No,
on that.
it's just preliminary matters on why I filed the bill of review.
She's
But I'll cut
not
that
been
short.
sworn as a witness. This is argument, and we're gonna let her talk.
Anyway, so I filed a petition for bill of review for many reasons, and it's currently pending. After I filed for injunctive relief, at the TRO, Mr. Berry showed up, convinced the court that they were not planning on proceeding here today.
I'm going to object that his
Well, the record-
misrepresentation of what took place, and I will put on testimony to that effect.
Overruled.
Well, the record will speak for itself, and it's being prepared. So he denied it based on there was no immediate need and no immediacy to any potential irreparable harm. So then after that, she immediately filed the proceeding here, and then she showed up at the temporary injunction hearing. and told the court that he didn't have jurisdiction because she had filed this proceeding here. So I have filed in the Supreme Court a direct appeal. And so for constitutional violations. And so what I'm objecting to today is that I believe that the Supreme Court now has, in addition to, the Supreme Court has jurisdiction, and I don't, this proceeding is going to decide an issue that's in front of the Supreme Court. And I think that the Supreme Court also, when it takes up jurisdiction, if it does, then it will have jurisdiction over this decision as well, and it may or may not vacate the underlying judgments. If it does, which I am claiming that they're void, then this proceeding is going to be void. I mean, so what I am asking is that this proceeding, be stayed until we finish at the Supreme Court, until they get the final decision on the issue. I think anything you do at this point is subject to being void. So as a matter of just economy, in addition, I shouldn't be subject to discipline that doesn't meet constitutional standards. So I have filed a plea to your jurisdiction, and so therefore I object to going further.
Does anybody have any questions before we hear from Ms.
I
Berry?
do.
Yeah.
I'm curious as to the plea to the jurisdiction. Are you contending the district court's jurisdiction didn't exist for purposes of the injunction? I'm not clear on whose jurisdiction, and your bill of review is attacking what? Is it the district court or?
The bill of review is attacking both of the judgments entered by the evidentiary panels.
Okay.
And it was my
I'm just curious of the procedural, the bill of
Right.
review procedure that's what I couldn't figure from your
Well-
answer, where you were.
well,
Your bill of review is not attacking the district court, it's a bill of review from the evidentiary panels?
right,
Okay.
and it's attacking the
I think I understood
Sorry,
what
I'm
you're
having a
saying. You
hard
were
time
saying,
talking
I
because
think
my
I
eyes
got
are
that,
gone.
the constitutional, some of the limits on your defendants and all, but I just am procedurally pondering a bill of review process to go from that panel to the Supreme Court. That's new to me.
well,
so.
in order to make a direct attack on a final judgment.
Sure, I understand
Once
that,
you've
but normally
exhausted
you
all
have
of your
another
appellate
process
remedies,
that.
then I filed a bill of review making a direct attack against the judgment for procedural and substantive due process reasons. That court has jurisdiction to engage in constitutional construction as well as statutory
They
construction.
have it, but they haven't. What's the status of your bill of review right now?
It's pending.
Okay.
She has filed a motion, Ms. DeBerry has filed a motion to dismiss, which is.
Do we have copies
We have
of
a
those?
copy of the bill of review.
I do not have a copy of the bill, well, I have, my
probably
copy
have one.
is marked up. I do have copies of my response, both to her request for injunctive relief where we claimed the court lacked jurisdiction, as well as we have a motion to dismiss the bill of review for lack of jurisdiction that is going to be heard on Monday at 9 o'clock in the district court in Travis County. A bill of review has to be brought before the same adjudicatory body to render the judgment. In this case, it's an evidentiary panel in Harris County. She filed in district court in Travis County, so there's no jurisdiction. But I have copies of both of our responses that were filed in that case.
And I may approach that because I don't have a copy of the bill of review with me. May I approach?
Are you offering those at this time?
Well, if you all would like, I mean, they're certified copies from the district court.
Do you have an objection to the offer of those as exhibits?
I do.
Were they filed in the district court?
They are.
Well,
And these are file stamp copies. I do not have a certified copy. These are copies that we file
Well,
stamp.
I would like to see what, before she's presenting it to you, I'd like to see what it is she's.
Okay.
You've received them.
I know,
You were
but I don't know what you're
certified
handing the court, and you do that all the time to
We'll,
me.
we'll allow you to look at the documents before they are
That's just
considered for.
Oh, okay. So just to be clarified, she does not have the transcript attached. She has her pleadings attached.
The two offered,
The-
excuse me, the two offered exhibits are admitted. And before we start back up, we're a little bit informal, but let's keep in mind that it is real hard for the court reporter to take down two people talking at once. And if we want a record, we aren't going to have one to do that. Please proceed.
The bill of review cannot be filed in front of the evidentiary panel. The evidentiary panel is made up of lawyers and non-lawyers. The non-lawyers are not trained in constitutional law, and there's Supreme Court, U.S. Supreme Court cases on the issue that those individuals cannot engage. In fact, the evidentiary panel is there to on a fact-finding mission in terms of determining the facts. They don't have jurisdiction to engage in constitutional construction or statutory construction. And therefore, it's not appropriate to file a bill of review in the evidentiary panel in Houston. We've gone through this in front of the district court here in Travis County. And you know, he agrees. He does have jurisdiction. It's in the 345th. So that's why it was filed. It was filed in Travis County because of the statutes requiring that the case be filed in Travis County, suing state bar. She objects to that court having jurisdiction. The court has already said that he disagrees with her. However, there may be.
That's not what was said, and she's testifying again.
I'll overrule the objection.
The Texas Supreme Court does have jurisdiction over the issue, and it's now in the Texas Supreme Court.
When did you file in the Texas Supreme
I
Court?
just filed it, so I.
Just filed it. When does that mean?
I filed that yesterday.
So you filed a direct appeal in the Texas Supreme Court yesterday on what issue?
On making a direct attack against both of the judgments for based on the statutory constitutional and statutory violations, and refusing or denying the injunctive relief. All right. Asking the
Why
court
would
to
you not
decide
have done
to
this?
vacate these judgments.
Why would you not have done this earlier? Because both judgments are several years old. Those issues would have been present back then, would they not?
Well, that's not the standard. The standard is you have to exhaust your appellate remedies before you can go to a direct appeal.
I thought
The
you had.
constitutional issues have not been addressed in a court, so they haven't been addressed before.
Could have been.
Could have been, but they are issues of fundamental procedural due process, and they're not waived.
You participate in all of the panel grievances and you've participated in everything to date, correct?
I was a witness,
And
yes.
you've had notice of everything to date? You've been.
Well, no, I'm not going to agree with that
That's
at
fine.
all.
You've answered my question.
A few moments ago, you mentioned that the word stay. What relief are you asking of us through this plea to jurisdiction?
Well, I'm asking you to dismiss this case because you don't have jurisdiction, because the Supreme Court has not made its decision yet as to whether it notes that there's probable jurisdiction there. I don't know if they're going to take that case or not. But I had to go through the procedure of going through the district court. I would have preferred that the case be decided there, but he did not grant the injunctive relief, and so we went through a direct appeal.
Is it your position that your filing in the district court deprives the Board of Disciplinary Appeals of any jurisdiction?
I'm sorry, I didn't hear.
Is it your position that your filing in the district court has deprived the Board of Disciplinary Appeals of any jurisdiction over the cases?
No, that was an issue that Ms. DeBerry brought up. Basically, her argument there was that if we went forward in Travis County, that we would be interrupting BODA's jurisdiction, and that's improper. However,
I understand there are two potentially different avenues. One is a request to stay pending a decision by the Texas Supreme Court in an effort to satisfy judicial economy. And the other one is something has deprived the Board of Disciplinary Appeals of jurisdiction. I see those as two different things.
they are, and
So what has deprived the Board of Disciplinary Appeals of jurisdiction?
well, having filed the direct appeal, the Supreme Court now has extended jurisdiction over the entire case. And so it is going to make a decision as to what, if it takes the case, then the decision that it makes will be whether or not to vacate these judgments. And it has jurisdiction above and beyond the board. I think there's even a question of whether or not, I don't know.
Is it your position that merely filing an appeal with Texas Supreme Court?
I'm sorry, I didn't.
Is it your position that merely filing an appeal with the Texas Supreme Court gives the court jurisdiction?
Well, it
I don't see how
gives,
court can have jurisdiction merely because someone files something in that court. That seems to be your argument. That is, I filed something in the Texas Supreme Court, therefore everything else comes to a halt.
well, that is not my argument.
Well, if it's not your
I
argument,
think, if you go forward today and then tomorrow they accept the case, then what we've done today is, potentially void, and then I'll be seeking emergency relief from the Supreme Court as a result of that, because then it will. By filing the case, they have jurisdiction over the case. What they decide to do with the case is just completely up to them. It's not, they may note probable jurisdiction and then ask for the case to be briefed or not. But they have jurisdiction. It's just, how they exercise that.
Ms. Wilkinson, did you ask them by any chance for, this sounds to me almost like when you file an original proceeding in a higher court, it doesn't deprive the lower court of jurisdiction. It in effect, the majority of folks would ask the higher court to stay, or for some ordering the lower courts or authorities to cease acting. Did you, and we don't have the benefit of your petition, but did you ask the Supreme Court to issue any kind of a stay or for any kind of emergency relief?
I have not. I'll just be real honest. I just ran out of time. I finished an appellate brief. The next day I had to file this in the Supreme Court, and then the next day I had to come here.
I'm not asking you.
It's not that I didn't think about it. It's just that.
Right. But do you agree that in a lot of original proceedings, such as writs of mandamus, prohibition, other other types of original proceedings filed, that you can have two bodies that you've got to get a stay to stop the lower court, and it's kind of the same argument you're making, judicial economy, you don't want to duplicate actions, and that, but, and that, you've answered my question as to whether there was any request for a stay pending, but you're basically asking us to stay it, to allow them to rule essentially on your bill.
Well, I'm using that term, but, I mean, basically I'm saying, first of all, I'm not sure that BOTA has the jurisdiction to determine the issue before the Supreme Court in the first place. And that is a question for the Supreme Court to decide.
The jurisdictional issue.
Right. So I've asked for you, for this case to be dismissed without prejudice. I mean, you know, I don't know what's going to happen right now. They may just, you know, and then, so, I mean, a stay is a whole different matter.
You're asking for the revocation to be dismissed.
Well, I'm asking for this particular proceeding today to be dismissed.
With prejudice?
No, I said without
Oh,
prejudice.
without. Okay,
I mean,
I thought
obviously,
your pleading said with.
no.
Okay.
She's not going to record it.
But I mean, I don't think that the appropriate thing is to say without prejudice. I just think it should be dismissed because I don't think you have jurisdiction. And, you know, then if they refile it, they refile it. I mean, I don't.
Okay.
Ms. Wilkinson, did you consult with the Texas Rules of Disciplinary Procedure on what it allows for appeals of evidentiary panels prior to filing your bill of review?
Well, I did, but in addition to that, there is U.S. Supreme Court case that states that non-lawyers may not, on disciplinary panels, number one, there's case law that says lawyers are entitled to due process, substantive and procedural due process in disciplinary proceedings. There's also a case law that from the U.S. Supreme Court that says non-lawyer decision makers in disciplinary proceedings may not engage in constitutional construction or statutory construction. They're not trained in either area of law, and they don't have the authority to practice law.
What are the rules
improper. So if I would have done that, because it would have been much more convenient for me living in Houston to file this in Houston. I would have preferred to do that, but I don't believe the evidentiary panel has the jurisdiction to do that.
What do the Texas Rules of Disciplinary Procedure say is the avenue for appealing an evidentiary panel judgment?
Well, you would go to the Board of Disciplinary Appeals, and then to the Texas Supreme Court.
And that's not what you did?
No, because it doesn't say that you can file a direct appeal to BOTA. And I have a question as to whether or not BOTA has the jurisdiction to make these determinations. I'm not saying that you don't have jurisdiction to determine, to engage in statutory construction, but I don't believe you have constitutional due process authority. And so I made it, and then I went to the district court in Travis County. He has not declined jurisdiction, and you know, I don't want to say what he said, but you know, I did what I did for a reason. So.
The hearing on the jurisdictional issue is Monday?
She has filed she's brought that up in a couple of hearings so far. She's filed a motion to dismiss, and that hearing is on Monday. But at the hearing, the judge, you know, told her that he does have jurisdiction over the case. What the concern there was does he have co-equal jurisdiction with, her point was that she had filed this proceeding, the revocation proceeding, in BOTA. And so she was claiming that by my filing the proceeding before she filed hers, that we were somehow interrupting her jurisdiction here. The proceedings are completely separate. This is a revocation proceeding. That's a direct attack on the underlying judgments. And so her claim is that he doesn't have, the district court does not have jurisdiction. That's a question that we don't have a decision on yet. And so he denied the injunctive relief, giving me the foundation to do the direct appeal.
Do we have any other questions from Ms. Wilkinson?
Question, and then if we were to rule that we had jurisdiction and we were to do a revocation, you would be able to appeal that to the Texas Supreme Court, correct?
I'd start all over on, it'd be a whole separate issue.
And
I mean, I would still have the ongoing matter.
You would still have your case in the Travis County District Court, whatever would happen there. You would still have your direct appeal, and you would still have the ability to appeal whatever judgment, if any, is entered in this case. Isn't that all correct?
Well, I don't know yet what would be going on in the Travis County courts.
Well, I don't either.
I don't know whether the direct appeal would be going on. I don't know. It depends on which entity does what. I mean, they will all still be active, and how they turn out is a question that's, you know.
Thank you.
I may have them, I may not. I don't know.
Is your license presently suspended or not?
No, it isn't. And, you know, my guess is they reinstated my bar card so that they could then proceed to revoke it again.
They reinstated bar card because that's what the judgment said. Your active time ran.
Well,
Isn't that
but
right?
if you have, they're claiming I haven't fulfilled the terms of the judgment, and I would think
That's
that
what
those
we're here
terms would
for,
need to
right?
be fulfilled before they reinstated my bar card. I mean, that's what I would think.
Is that what the rules of disciplinary procedure say needs to happen?
Pardon me?
Is that what the rules of disciplinary procedure say happens in that instance? I mean, what you keep saying what you think, but there are rules
I'm
that
sorry.
specify how things are going to happen.
Well, the judgment says what's going to happen, and it says that those things are going to happen before my bar card is reinstated, and that's not what happened. So why, I don't know. I'm not the one who did it. My guess is they wanted jurisdiction.
Sounds like to me that you're arguing that you shouldn't be reinstated, in which, if that's the case, then all this is moot.
No, my argument is that the judgments are void, and it should never have been suspended in the first place. But that's an issue that has to be argued and decided in another place and time. But I guess what I thought was that they must have reinstated my bar card so they'd have jurisdiction to revoke it or something. I don't know. I mean, I had done everything I could to pay everything that I could. I've lost my house. I've lost everything. So, and my aunt has committed suicide. So she told the bar to stop this. And she's severely mentally ill.
We're here right now on the jurisdiction, whether we have jurisdiction or not. And it's pretty finite. And do we have any other questions on the jurisdictional matter? Do you have anything else for us on that issue?
No, I did file my plea, and I've been told you all have copies of
Yes,
it filed last night. So last night.
And we've read it.
Okay.
If you have nothing further for us on this, I'd like to hear from Ms. DeBerry, then I'll give you a couple minutes to respond to whatever she says. Ms. DeBerry?
Very briefly, in the Richards case, it's real clear that there is no jurisdiction for her bail review in the first place. This board has jurisdiction to hear revocation proceedings. It's that simple. And I think that unless you have specific questions, I don't see that her argument holds any water.
Any questions? Do you have anything else? Are you familiar with the case she's citing?
No, I'm not, and but I
Do you have a cite
don't
for
wanna
that
be-
case?
I do, it's, actually, it's in the materials you have, because I cited it in those.
I may have it, I have a box that I didn't bring with me for research, so it's possible that I've pulled it. I
Richards-
think I've pulled most
Richards-
of the cases
One-
that
one at a
you
time.
cited.
Okay.
I
All I'm
just don't
asking
have it
is,
with me.
do we know a cite for it?
Yes, 81 Southwest 3rd, 506.
Okay.
It's it's out of the First District Court in Houston. That's regarding jurisdiction just to file a bill of review in the first place. The other jurisdictional issues that we argued for the temporary injunction are also cited in my response to that. She has those as well.
Any other questions? Anything further?
Well, I don't think I have that case with me, but I have pulled those cases, and we have gone through this same argument in front of the district court, and the district court has not agreed with her, and
Okay.
she has argued those cases already.
There being no further argument on this issue, what we're going to do is take a 10-minute recess on 52540, Kristin Wilkinson. We have considered the plea to the jurisdiction and have concluded that we do have jurisdiction, therefore it is overruled and denied. We have also considered a motion to stay, and that motion to stay is likewise denied. We will proceed on 52540. And I believe Ms. Ashcraft was on the stand when we took our hiatus to consider plea to the jurisdiction. And as I recall, Ms. Wilkinson was considering further questions of Ms. Ashcraft. Ms. Ashcraft would like to take the stand again. The witness has previously been sworn, so Ms. Wilkinson, you may proceed.
Ms. Ashcraft, the payments that were made to you as a representative of the State Bar by me, was that under a particular kind of a payment plan?
Correct.
And what amount did we agree that, or did you require me to pay on a monthly basis?
You agreed to pay $500 a month beginning June 1st, 2010.
Okay. And did I, at any point before that agreement, tell you that I could not afford that?
You mentioned you mentioned that you could pay $500 a month, but you wanted the 60-day rule to cure any default payments.
I object as non-responsive.
I'll sustain the objection.
Did we ever have any conversations where I informed you that I could not afford to pay $500 a month?
You wanted to pay $250 a month, but then you agreed to the $500 payments per month.
Object as non-responsive.
I'm going to sustain the objection. I believe that your testimony is on a different matter and not the one that the revocation is pending before. Is that correct?
That's not my understanding. My understanding is that Ms. DeBerry has attached both judgments to her motion.
Mr. Berry, which judgment is the revocation sought on?
The revocation is sought on the 2011 judgment. The information, the evidence presented on the other is simply to show a pattern of noncompliance with disciplinary judgments. And so this is not the first time she's not complied with the judgment.
I'm not sure of the relevance of that. It's been, we can consider, we will determine that later, whether it's relevant. I think that probably the focus is on the judgment on which revocation is sought and whether that the terms of that judgment have been complied with or not.
Okay.
So I don't know that we need to go into a whole bunch of different things and a bunch of different detail. I think that's what is really before us.
Well, I have to object to that because she's offered her pleadings into, and they've been admitted. She's attached both judgments. She's opened the door to cross-examination of her witness on both judgments. She's seeking the revocation based on both judgments. I mean, I didn't.
Go ahead and ask the witness a few questions on the earlier judgment that I think the focus, I don't want to deprive you of your time. We don't have, an unlimited amount of time. I don't want to lose focus on the judgment on which revocation is sought. Go ahead.
May I proceed?
Yes.
I'm going to ask that question one more time. Did we have communication where I told you that I could not afford $500 a month?
You had asked for a stay.
I object as non-responsive.
Sustained. Ms. Ashcraft, do you remember a conversation where she said or didn't say that she could afford it, regardless of other conversations or agreements?
She said she could pay $250 a month.
Go ahead.
I object as non-responsive. Ms. Ashcraft, did you ever agree to accept $250 a month?
No, that was not accepted.
I have no further, I'll pass the witness.
Any further questions?
I just have one quick question. I'll pass the witness, that's fine.
Anybody have any questions for Ms. Ashcraft? Ms. Ashcraft, you're excused.
Thank you.
Mr. Berry, you have further witnesses?
Maybe I'll call Kristin Wilkinson.
Excuse me?
Call Kristin Wilkinson.
Ms. Wilkinson? Yes.
Raise your hand. Do you solemnly swear or affirm the testimony you give will be the truth, the truth, and nothing but the truth, so help you God?
Please state your name for the record.
Kristin Wilkinson.
And how are you currently employed?
I'm a sole practitioner.
Is that your only source of income at this time?
Yes, but I don't have any income from the firm.
So during the time you were suspended, what jobs did you
I'm
have?
sorry, I didn't.
During the time you were suspended, what jobs did you have?
During the time that I was suspended, I spent every minute of my time. I had
Non-responsive. I just asked her what job she had during that time. Please answer the question.
I will. I had obtained a judgment against a child molester.
Objection, that has nothing to do with that's non-responsive.
Ms. Wilkinson, I think the question is, were you acting as a lawyer?
Well, obviously not, no.
Okay. What sources of income did you have?
None. Okay. One source of income was we were in the post-judgment collection phase of a jury verdict. The judgment was reduced. The jury verdict is about $6 million now. So,
Other than that, what sources of income?
none other than that, and none has. What's happened in that case?
Objection.
Is the receiver has stolen
Objection.
all of the money.
Okay.
So I don't have any money, and I've lost my house. Otherwise,
I'm going to object as non-responsive to the question I asked.
I have
I'm
spent
overruled
every
the
minute of
objection.
my time trying to stop the pilfering by the receiver of this little child's money and my fees. And I have not been able to collect. There's a couple $1 million that we could have collected. It's all gone. And had I had the money, I'd have paid the judgments here and gone on with my life. But instead, I have, with no income, spent every minute of my time trying to stop that from happening. And
I think that answers
I
the
haven't
question.
been able to do it because
I think that answers the question. Ms. Berry, do you have anything
So,
further?
yeah, during this time, you had no source of employment at all. Is that correct?
no, and you can certainly look in
That's-
the record.
thank you.
There's nonstop.
So how did you support yourself?
I didn't.
Who supported you?
I object as relevant.
Well, you're claiming you
I,
had
I'm
no...
going to sustain the objection. I think the issue is whether the judgment was complied with or not. So let's see if we can't focus on that.
So you're claiming you had no source of income. Have you brought any bank statements here with you today? That's a yes or no question, Ms. Wilkinson. Did you bring any bank statements to support the fact that you have no income? I'll take that for no then.
Don't.
Did you-
Do not put words in my mouth.
Then answer the question yes or no. Did you bring bank statements to show that you had no income?
Well, you know what? Y'all had access to all my bank statements, and so what else do you want to see? No, I didn't bring anything else with me. You have everything.
Did you bring any income tax statements to show that you had no income during the past 2 years?
No.
And so even though you were found in both the prior judgments for violating Rule 8.04A3, engaging in conduct involving deceit and misrepresentation, you're asking this board to believe that you had absolutely no source of income without any substantive proof of that. Is that correct?
Well, actually,
Is
the
that correct?
evidence is, no, I'm going to answer the question. The answer is objectively verifiable. Anybody can go look in the public record and see there's been nonstop pleadings in every court under the planet, including the district attorney's office, trying to stop this guy from stealing my money. I've done everything I can, and it's cost me a fortune trying to stop it. So, you know, and I've had to borrow money to do that.
And
So
you-
if you, and
Who's the
let me tell
lawyer
you something.
filing those pleadings?
Pardon me?
Who's the lawyer filing the pleadings that you're talking about?
I filed them pro se on my own behalf. Anybody has a constitutional right to represent themselves, so if you're claiming
I'm aware
that-
of what it is to be a pro se lawyer, so please don't waste our time with that. I'm asking you who filed the pleadings. You've answered that question. Thank you.
I filed the pleadings. I also retained a lawyer in some of the pleadings as well.
And who is that?
That was, his name has just popped out of my mind. Anyway, I terminated him, so I'm sorry.
When you filed the bill of review in Travis County, you did not file an affidavit of indigency, did you?
No, I've done
You-
everything
you
I can
paid-
to not
you paid
require
a
the
filing
government
fee,
to.
correct?
Okay, let's not talk at the same time.
Yeah, I
and
mean, I
even you,
object to her not allowing me to answer the question.
let's not all talk at the same time so that we have a record. And if you filed a affidavit of indigency, you can tell us. If you didn't, tell us. The question is not why, it's whether you did or not.
No, I have not.
Okay.
And you paid the filing fee for that, correct?
For
That's a
what?
yes or no question. For the bill of review, you paid a filing fee.
Yes.
correct? And you have, in your notice of appeal to the Supreme Court, I believe you said you'd made arrangements for payment to obtain the record, and the clerk's record, and the reporter's record in that?
Right.
So you had the money for that,
No,
correct?
I didn't.
But you were able to get the funds to do that, correct?
Yeah.
And isn't it true that the pleadings you filed, both your first petition for bill of review and your amended petition for bill of review, are approximately 400 pages long?
I didn't count the pages.
So that
I
record...
don't think it's 400 pages. I think it might be 100 or 70. It may be 100 pages. I don't know.
With all the attachments?
Yeah, I don't think it's 400 pages.
Have you been told how much that record's going to cost?
No.
And they charge $1 a page, is that correct?
Yes, they do.
So you were able to come up with that money?
No, I just answered you, and I said, no, I haven't. I don't know how much it's gonna cost. I haven't paid it.
But you claim you've made arrangements to pay it. That's
Well,
what
I
the
wouldn't
pleading
presume what
says.
those arrangements are, but yes, I have had discussions with the court reporter and the clerk's office as to what they want to require. I mean,
So
I don't have an invoice, so I have no idea what they're gonna charge.
Currently, you're living with an elderly lady, is that correct?
No.
You're not?
Well, yes, my mother.
Oh, you're living with your mother now?
Yes.
Okay. So you don't pay rent? These are issues that
Actually, I just moved, literally, so I literally just moved in with my mother, so we haven't even had a chance to sit down and talk about that, so.
So prior to moving in with your mother, where did you live?
Pardon me?
Prior to living with your mother, who did you live with?
I object as relevant.
I think it's relevant to, you're claiming you don't have the ability to pay anything. I'm trying to establish where you've had.
I think what we have is there is evidence of some income and some expenditures that are being made. The money must be coming somewhere. We get that. We understand, and the exhibit has been entered with Ms. Wilkinson's email about some of the reasons she's claiming that she is unable to pay. We've received that evidence, so I think we're just kind of beating a dead horse. We've heard testimony, and I believe it's cumulative.
Okay. Let me just make it real quick. When you were living with Ms. Godley, were you paid for providing any caretaking services to her?
Was I paid by her?
Mhm.
No.
By anyone to take care of her?
No.
So you received no compensation?
No, I wasn't there for the purpose of taking care
Okay.
of her.
I want to talk just a minute about this case that you brought up, where you claim the receiver is stealing all the money. Isn't it true that all the funds in that case are in the court's registry?
Absolutely not.
All the funds that have been turned over to the receiver have been put in the court's registry.
No.
And the court has made orders for every payment that has been issued out of that registry. Isn't it that the truth?
No.
And isn't it true that, in that case, that an IRS lien was paid?
An
Yes
IRS
or no?
claim that had no priority and
that's-
it was paid, yes it was.
And the court
And
issued
I objected to it.
the court issued an order and ruled against you and paid that, correct?
I object to the characterization of the question
And the
because no,
court
that's not
also-
exactly what happened.
The court also issued an order directing that a child support lien be paid, correct?
Yes, and again, that was a non-priority lien.
And the court also
It wasn't even a lien, but.
I'm just asking yes or no questions.
Well,
I don't
you
want to.
can't, I mean, you know, you're trying to make it as if I'm just
I'm
all
gonna-
wrong and the court's done it all right. And
Well-
the truth is, I'm right, okay?
Ms.
That-
Wilkinson?
And you can ask my expert, Michael Quilling, who will tell you that you can line up a whole room of lawyers and they'll all agree this should never have been done. The receiver should never have asked the court to do what they did. That was a violation of
I'm going to
fiduciary
object as
duty.
non-responsive. I'm just trying to ask simple questions so we can get
I
out of here.
sustain the objection. Ms. Wilkinson, if you want to go into some of this in a very limited manner in your testimony, you can do so, but let's just cut
Okay.
to the chase and answer the questions.
And that the court also issued an order for Terry Yates's attorney's fees to be paid in that case, correct?
That's correct.
And that the victim in that case, who I think you may have claimed you represented, was paid $128,000 by order of the court. Isn't that correct?
I've never heard about that one. Maybe they have.
And that there
sure-
is, and you received advances from Williams Kirker in the amount of approximately $48,000 for expenses and advances. Isn't that correct?
It wasn't, no, they've never paid me any advances.
They never gave you any money for expenses, for research? Is that what you're testifying to? They didn't pay you $20,000 on,
Pardon me?
they didn't pay you $20,000 on 6/07?
We had a contract where they gave me a loan. They based that
Thank you.
loan on the expenses in the
That-
case
That was part
at
of
that
it.
time, and that was in 2007.
Correct, but I'm saying that those funds are also due back out of that judgment that you claim an interest in, is that correct?
The loan will be paid, or should be paid out of my portion of whatever I get out of the case.
Okay, so there are other people.
Are we close?
We're close. I'm through.
Okay.
Because as Mr. Lee said, I mean, the issue is whether or not there were amounts that you set forth in your motion for revocation. There were amounts owed under the second judgment and whether or not those have been paid.
We understand.
And you've made absolutely no payments on the second judgment at all, isn't that correct?
That's correct.
Thank you.
Ms. Wilkinson, let me remind you, that, you know, we've seen the email that goes through some of your contentions. I think many of them about your ability to pay. It's been admitted as an exhibit. Okay. So I don't want to have duplicative evidence of that we already have before us. So keep that in mind as you're.
So you're telling me not to testify on my ability to pay?
Well, if we already have that evidence, I don't want to hear it 2, 3, or 4 times. I mean, if we've heard it, we've heard it. So if there's something.
Well, you haven't heard it from me.
Okay. Well.
It was your email.
It was your email.
It's the email you typed.
Well, okay, that's fair.
Okay. Are there things that aren't set forth? And I've read your email. I think we all have. Are there things that, in addition to that, or things that you want to clarify in that briefly for us?
I don't have it in front of me, but I will say this. Regardless of, had I had, whether I feel that the judgments were void or not, had I had the ability to pay, I would have paid them. And if I wanted to go file more proceedings and be tangled up in more litigation over the judgments, then I would have pursued that. The issues of whether or not I think that they're void and whether or not I'm paying them are completely separate to me. I am not paying the judgment because I think it's void and I shouldn't have to pay it. I am not paying the judgment because I have no money. I have done everything to stop the receiver. There are hundreds of thousands of dollars that are gone. We can account for how much they said that was coming in. We can account for how much they actually deposited. And there's hundreds of thousands of dollars of difference. In addition, without my consent, I have an assignment. I have an assignment, a contractual assignment in the judgment. I also have an assignment by court order. So without my consent, they cannot give the money to somebody to whom it doesn't belong. They have never put any evidence on in the entire case about the priority of these liens. There has been no claim that has any validity or priority in this child molestation case. Mr. Yates has what he calls an assignment that doesn't. There's no even proof that the judgment debtor signed that. It's not notarized. He never perfected it. He's never filed a. It's an assignment of fees to pay the criminal defense lawyer fees who represented the man who molested the little girl. he paid that guy instead of paying the little girl who's the victim. And, you know, personal injury fees are exempt, but if he wants to perfect that assignment, he has to go file a financing statement. And you can't file a financing statement if you don't have a document that's been notarized. He has done nothing to perfect that lien. And they gave him $52,000. But that is the level of what I've been dealing with.
Okay.
And so whether or not the judge allowed them to do that, all that does is make a statement about that judge.
Ms. Wilkinson, can I ask a couple of questions right quick? Number one, I heard some testimony on the prior judgment that you'd worked out a plan to pay $500 a month and paid part of that, and then apparently quit paying because I'm assuming you didn't have the money. Is that correct?
Right. I mean,
Okay,
I
now
lost
let me
my
ask you-
house. I literally.
Let me ask you this. On the judgment that we're here on today, did you have any discussions with the State Bar about a payment plan? And did you reach any agreement with them on a payment plan?
No, well, you know, it seems like I recall having a discussion, but we never reached anything. And, you know, I told her that I can't afford $500 a month. And
I'm talking about the second
initially,
judgment.
so she was not willing to lower that payment. You know, I'll do whatever I can. You know, I'll do it lower for a few months and then, you know, and then increase it. I'll do whatever I can, but that was just not acceptable. And so she wasn't going to negotiate on the second judgment at all.
Okay, that's fine. Let me ask you, Ms. DeBerry mentioned something, and I know you apparently disagree with it, that the money in this child molestation case is in the registry of the court. Do you know how much money is in the registry of the court?
Right now, there's $80,000, and they refuse to. I have filed motions for distribution up one side and down the other. I could pay the judgment if they would just give me my money. It's been sitting in the registry of the court. You know, I mean, I could give you a lien for it, but I don't know what the judge is going to do.
Is it your contention that you're entitled to the full $80,000 that's in the registry of the court?
Well, yes, but, you know, there's been so much money that's pilfered. I mean, I would never do that. I mean, because, you know, my little client, or a former client, you know, anyway.
Thank you.
But yes, I think I'm entitled to it.
Thank
and
you.
I have thought about, you know, offering up an assignment. But the thing is that the case has been so crazy that, you know, I don't know whether, I don't want to offer up something that I can't assure that's going to be paid. I don't know what they're doing.
Thank you. You've answered my question.
So, anyway, I mean, I don't know what else to do. I've done, you know, regardless of how unjust or lack of due process or any claim that I have, it's got nothing to do with my intent or willingness to pay the judgment or anything. It's just, I have literally been destroyed by the State Bar, and at this point I kind of feel like they don't want the judgment paid. They just want to hurt me because now they want to suspend my license for 2 more years, which just means that, you know, I mean, it doesn't make sense to me. I mean, you know, if you don't want someone to practice law, you don't want someone to practice law, whatever, that makes sense. But
Let me make
paying the judgment doesn't.
Let me make sure I understand what your position in your testimony is. That there is a judgment that has a monetary factor to it, and that judgment has not been paid, correct?
Right.
If you had the money, you would pay it, correct?
Without thinking, I'd pay it.
And for a myriad of reasons that are very complicated and involved, that you have testified to and that there's in the email, and there are probably, we could spend hours and maybe days talking about all the reasons that money has not been available to you, correct?
Right. The judge in the case the same judge who's done all this has also found that I have perfected my interest in the case. So it's not, you know.
Do you have things that you want us to consider in addition to that? Because I think we've heard testimony and received evidence of all of those things. So we have that before us.
You know, literally every minute of my day has either been trying to keep a roof over my head or working out arrangements or taking out a loan to pay this, all of my living expenses, to try to stop what's going on in that case. And I would like to say that at the evidentiary panel hearing in the West case, two of my clients came and testified at a motion for stay. A motion to stay during the appeal, so that my license would not be suspended while on appeal, because I was in the middle of representing these two ladies in separate cases. And they testified, they gave evidence as to what they thought of me as their lawyer, and how much trust they have in me, and how I treat them, and what they want.
object to hearsay?
It's actually been, it's in the record. It's not hearsay. I have a record. The record's been sent up.
My concern about it is that it's not relevant to the probation revocation. And I know it is supportive of you, and I understand that. But I think it's getting off of the basis that we're here today, and that's probation revocation. So
my point is that the public, they wound up losing their lawyer, and the public was injured as a result. I mean, under the rules of disciplinary procedure, if you file a motion for stay in a suspension case, you should, and there's no controverting evidence offered, which there was none, they should have given me a stay. Okay, I've lost, that was I lost that whole contingency fee. That could have paid the judgment. I've done everything that I can do to try and preserve any money that I have so that I can pay this judgment. And at every point, either the state bar itself has stopped it, or or the individuals who are working in the receivership have done that.
do you have additional evidence that you would like to put on today on the probation revocation? It's not cumulative of what we've already heard.
Well, I'd like to, I was going to ask you to take judicial notice of the pleadings. However, I didn't bring them with me. But it's all a matter of record. Everything that I've said, I'm not engaging in fraud or misrepresentation. I don't do that. I don't need to do that. I'm not afraid of any fact. I'm not afraid to tell you anything you want to know, as long as it's not totally violating my privacy. Anyway, so other than that, no.
Mr. Berry, do you have further questions? If not, I'll see if the
I just
board...
have one question. What efforts did you make to find a job while you were suspended?
Well, I sent out resumes. You know, it's a whole different ballgame of finding a job that's not in the legal community. So, you know, I talked to headhunters and sent out resumes whenever I found something that I thought I could do that was in management or something on a business level, working for a company or something like that. But I've had the ongoing appellate matters in these cases as well as the other matters, so I really haven't had a lot of time. No, it is responsive. You want to know what I've done. I have to consider what kind of time I have available, because if I go take a full-time position in a management of a company, then I'm not gonna have the time to preserve the assets in the receivership, and they're being pilfered up one side and down the other. And that little girl that I represented since 2002 is being stolen from. And it is utterly disgusting, but anyway. So, you have to look at all of these things. I can't not be fair to a position. I haven't been offered a position, but I've sent out resumes.
Okay, Mr. Berry, do you have further questions? Anybody on the board have questions? Okay, do you have any further witnesses?
I do not. I do not.
You do not? Okay. Ms. Wilkinson, do you have witnesses?
I've put my evidence on through the cross.
Okay, do you have documents that you'd like to admit as evidence, or anything else that you want to offer us?
Well, I other than I've asked the court to take additional notice of the file in both of these cases, the West case and the Calhoun case, including the evidence that was offered of my aunt at the proceeding that is excluded. Those included all of
Objection, that's the first case, that's a 2009
Well,
case.
let me cut to the chase on take judicial notice. We'll take judicial notice of whatever we have in our files, something that is in somebody else's files that we don't have before us. I don't think we can take notice of. So,
I agree.
okay. Anything else? Or any other witnesses?
I wasn't finished. There was one thing that I wanted to mention, and now I lost my train of thought. So I don't have any other witnesses.
Does movement, or does do you rest? The parties rest?
We rested.
Ms. Wilkinson, you rest?
Yes.
Why don't we, you can go ahead and return to the council. Ms. DeBerry, will you close your evidence? Is your evidence closed? Close and rest?
We've rested, yes.
Okay. We'll have closing arguments in a minute, but the evidence you have no further evidence to put on, correct?
I do not.
Okay. Ms. Wilkinson, you have no further evidence to put on, correct?
That's correct.
Mr. Berry, can you give us 7 minutes worth of closing?
I can probably do it shorter than that.
Okay. That would be nice.
Very quickly. The judgment was clear that she owed restitution and attorney's fees. She's made no effort at all to pay that. She testified that she couldn't take a full-time job, so she's made no effort to get a job rather than sending out resumes. She didn't testify that she'd even tried to get a part-time job anywhere. So I see no effort on her part to take any steps in order to pay either one of those terms of the judgment, especially restitution. The fact that she's managed to have funds to file pleadings in district court without doing an affidavit of indigency leads me to believe that she has a source of income somewhere. She's made arrangements to pay for the record and so on, and yet she can't pay anything towards the restitution. I find it untenable, and I respectfully request that her probation be revoked.
Thank you. Ms. Wilkinson?
I do not have to request public assistance in order to prove that I don't have any income. I don't have to file an indigency affidavit. If I want to make, there are a lot of people who know me very well and know every single thing that has happened, and know everything about the Madison case, and know everything about the Cook case, and know everything about the West case, and everything about my Aunt Vera Calhoun. And have done nothing but supported me left and right. So I don't have any money. I have, anyway, I don't have any money. To say that I have done nothing to pay these judgments is ludicrous. I have just told you that I have with interest, it's over $6 million judgment, with at least $2.5 million that should have been collected by now years ago. I have offered an assignment of my fees to pay the judgment. I have told you that in the Cook case, and there's a record of every single bit of this on file with BOTA, of the Cooks asking for a stay during the appeal so I could continue to represent them. The Cooks had to go find another lawyer, and I wound up, they agreed to well, anyway, I lost that fee. That fee would have been plenty of money to pay the judgments. Had I done nothing, I wouldn't have filed for a motion to stay. I wouldn't have done anything to try and preserve the money that I had coming to me. I have endlessly, I have incurred loans to people that now I have to pay back so that I can preserve the Madison case and stop the pilfering. I've now got to pay all of those people back. And I could just walk away and say, you know what, forget this stuff. I'm shocked that the State Bar has done nothing to the lawyers who have stolen this child's money. I am shocked. If there weren't people who thought very highly of me, I would have had to have walked away from every bit of it because nobody would have loaned me the money. I never realized how many wonderful people I have who do support me, and they're appalled at what's happened. My aunt, in a psychotic whatever, filed this grievance against me and then refused to testify at her deposition and demanded that the case be dismissed. And I understand that under the rules, the State Bar does not have to dismiss a case, but from then on they began to exert influence over her, and her mental state she's very subject to influence, and now she's killed herself. In those records that the State Bar refused to look at, she was telling her psychiatrist that her sons were abusing her, that they wanted her money, that they were forcing her to do this grievance against me, and that all they wanted was her money, and that she has already started a plan on how she's going to commit suicide. Nothing could stop the State Bar. At some point, you have to kind of step back and say, what are we doing to this person? Now she's dead, and I am appalled. And the judgment doesn't even give her anything. It just gives the State Bar a bunch of legal fees. She didn't get anything. She got to watch her niece, who has taken care of her ever since I was 8 years old, on and off, have her license suspended. That's all she got. And so she kills herself. I hope the bar is really proud of its handiwork. So, they could have stopped, but they wanted to rack up a big legal fee, which is all they did. So, I'll continue to pay those legal fees if, or I could just go file bankruptcy and say, hey, why am I putting myself through this? Why am I busting my rear to preserve the assets of this little child who was molested? The receiver is paying her molester's fees, which are completely subject to the judgment being completely satisfied. And why is the bar not pursuing those people? Some of those people are on the commission, and some of those people happen to used to be on the board. Well, I find it amazing that you keep attacking me. I'm so buried all the time. I guess if I just quit, maybe I'll blow my brains out. I mean, that's what I think you people want. You're not, that's not going to happen. I can't, I step back and I'm like, I'm so sick of the filth. I can hardly even think straight. I get no sleep, and I have offered you people everything I have. And you want to suspend my license because you think that I am committing fraud. Nobody I know would ever say that about me. And you know what? I'm not accepting that moniker. I know who I am and what I am and what kind of people I represent and how hard I work for them and what I do. And if I can't remember a rule of disciplinary procedure today, it's because I haven't had any sleep in 2 days. I drank that water, that little glass of water, I downed it because I haven't had anything to drink all day. But I am constantly putting myself behind my clients.
Ms. Wilkinson, we appreciate your comments, and we appreciate how frustrating
And all I hear from the board is, cut it short. We don't really want to hear from you. And that is disgusting. It is disrespectful. It is unprofessional. I have law loans that have to be paid. Do you think about anything but your precious, we don't want to hear from you? That is appalling. You are wanting to take away my license, which, by the way, is a substantive right. You want to take it away, and you don't want to hear from me.
I want to hear from you, Ms. Wilkinson, on the matter that we have
I'm getting a little emotional because my family has been trampled by the state bar.
Okay. I want to hear from you on the matter that we have before us. And we've gone far afield, and I understand that. And I have been willing and happy
My credibility,
to hear
my
from
honor is being attacked by Ms. DeBerry, and I will defend that every day of my life. I will not accept this moniker. I'm tired of people coming to me going, well, we read that stuff in the state bar. We know what happened to you. I mean, it's as if everybody reads that and I'm just like a sitting duck. Everybody wants me to work my tail off and then they don't want to pay the fee. Because I'm going to go file another grievance against you.
Do you have any more concluding remarks, not evidence, concluding remarks on the probation revocation for us?
I have done everything under God's green earth. Michael Quilling testified for me. He called it, she's done everything in hillbilly hell to stop all of this stuff from happening in this receivership. I have done everything I can possibly do to preserve my assets so that I can pay the judgment and keep a roof over my head and just live like a human being. So for Ms. DeBerry to get up and say that I've done absolutely nothing is just, I guess if the state bar just disregards all the truth, call Kristin a fraud, insult her, and refuse to even deal with the truth, then I guess you should do whatever it is she wants to do. I think she's flat out wrong. And so, I don't know. I've told you everything I've done. I don't know what else to say.
Well,
I certainly don't think you should revoke my license. How are you going to get the judgment paid? I mean, if the restitution is so important, then, I don't know.
we thank you for coming, and thank you for offering your evidence and testimony. We are going to take this under advisement, and we will inform the parties in writing of our decision.
May I be dismissed?
Yes.